A major legal battle over climate funding has taken a surprising turn, with a federal appeals court siding with the Trump administration in its effort to stop a $16 billion green bank initiative from being abruptly halted. In a 2-1 ruling, the court ruled that the Environmental Protection Agency, EPA, was justified in freezing funds and ending contracts with nonprofit partners, dismissing claims that the move was an overreach. This decision has sparked intense debate about the balance between government oversight and the rights of environmental advocates. But here's where it gets controversial. The court argued that climate groups shouldn't have been allowed to challenge the EPA's actions in district court, where such disputes typically aren't handled. Instead, the case should have gone to a specialized federal claims court, which deals with contract-related issues. This shift has left activists feeling frustrated, as they believe their legal arguments were dismissed without proper scrutiny. The EPA's push to terminate the Green Bank program, aimed at financing clean energy projects, has been criticized as a waste of taxpayer money. Administrator Lee Zeldin accused nonprofits of mismanaging funds, while the Biden-era program itself faced backlash for its ambitious goals. However, a lower court had previously ruled that the EPA couldn't justify ending contracts without concrete evidence of wrongdoing. The appeals court's decision now forces the case into a different legal arena, raising questions about how such disputes should be resolved in the future. Climate United Fund and other organizations sued the EPA, Zeldin, and Citibank, arguing that the freeze violated federal law and threatened their operations. They claimed the EPA had no right to withhold funds that had already been legally awarded. Yet the appeals court maintained that the dispute was fundamentally contractual, not a matter of constitutional rights or public policy. Judge Naomi Rao, a Trump appointee, wrote the majority opinion, stating that district courts lack authority to hear claims about arbitrary government actions. Claims of arbitrary grant termination are essentially contractual, she noted, emphasizing that the case should be decided in a forum better suited for contract disputes. However, Judge Cornelia Pillard, appointed by Obama, dissented, arguing that the EPA had failed to provide credible evidence for its actions, undermining Congress's intent. This ruling has left activists questioning whether the legal system is adequately protecting their rights. While we are disappointed by the panel's decision, we stand firm on the merits of our case, said Climate United CEO Beth Bafford. EPA unlawfully froze and terminated funds that were legally obligated and disbursed. As the case moves forward, one thing is clear: the fight over climate funding is far from over, and the legal battle will shape the future of environmental policy.